The Supreme Court chamber fell silent as Elon Musk stepped forward to the petitioner's lectern, adjusting his navy blue suit with an uncharacteristic hint of nervousness. The tech billionaire had bypassed his attorneys to personally argue his company's landmark case against federal regulatory overreach. Across from him, Chief Justice John Roberts and Associate Justice Amy Coney Barrett exchanged subtle glances that didn't go unnoticed by the packed gallery. Mr. Musk, Roberts began, his voice carrying the weight of his position. You've made the unusual decision to represent yourself before this court. While you're entitled to do so, I must remind you that this is not a tech conference or a social media platform. A ripple of nervous laughter moved through the audience. Barrett leaned forward, adding with unmistakable condescension, the legal questions before us today are extraordinarily complex. Are you certain you wouldn't prefer your attorneys handle this matter? Musk stood perfectly still, his expression unreadable as the justices continued their thinly veiled attempt to undermine his credibility before he'd spoken a single word on the merits. What happened next would shock the courtroom, overturn decades of legal understanding, and force even his harshest critics to acknowledge a side of Elon Musk that few had ever witnessed. This wasn't just another eccentric billionaire moment. It was about to become one of the most remarkable displays of legal brilliance ever witnessed in the Supreme Court. Before we dive into this extraordinary courtroom confrontation, make sure to hit the subscribe button and turn on notifications to catch all our latest analyses of today's most significant political and legal battles. Chief Justice John Roberts, 69, had presided over the Supreme Court for nearly 2 decades. Known for his institutional conservatism and dedication to protecting the court's legitimacy, Roberts had navigated the increasingly polarized legal landscape with careful pragmatism, with his meticulous preparation and encyclopedic knowledge of constitutional law. Roberts had rarely been challenged or surprised in his courtroom justice. Amy Coney Barrett, 52. The court's youngest member had quickly established herself as a formidable intellectual force since her controversial confirmation in 2020 with her background as a respected professor at Notre Dame Law School and her strict textualist approach to constitutional interpretation. Barrett was known for sharp, incisive questioning that often exposed the weaknesses in attorneys' arguments. Together, they represented the full weight and authority of America's highest court, an institution that had humbled the most seasoned and brilliant attorneys in the nation. Across from them stood Elon Musk, 53, the controversial tech entrepreneur whose companies had revolutionized electric vehicles, space travel, and now social media. Known more for his engineering prowess and unpredictable public statements than his legal acumen, Musk had shocked the legal world by dismissing his high-powered attorneys and filing a petition to personally argue his case before the Supreme Court. The case. Federal Communications Commission involved complex questions about the government's authority to regulate digital speech platforms. Lower courts had consistently ruled against Musk's company, finding that recent FCC regulations on content moderation were constitutional exercises of federal authority. The financial stakes for Musk's company were enormous, potentially billions in compliance costs and fundamental changes to the platform's operation, but the personal stakes for Musk were equally significant. For years, critics had dismissed him as a brilliant engineer, but an impulsive and undisciplined thinker. Outside his technical expertise, this appearance before the Supreme Court represented either the height of his arrogance or an opportunity to prove his intellectual capabilities extended far beyond rockets and electric cars. Mr. Musk, continued Roberts, this court's time is extremely valuable. I hope your decision to argue personally won't waste it. The Chief Justice's tone carried an unmistakable message. He viewed Musk's presence as a publicity stunt rather than a serious legal endeavor. Barrett added, the briefs submitted by your former counsel were quite thorough. I'm curious why you felt they were inadequate. The question was a subtle trap. Either Musk would criticize his own legal team or admit his appearance was unnecessary. The courtroom tensed as Musk adjusted the microphone. Court observers exchanged glances, most expecting an embarrassing display from a billionaire out of his depth. What they didn't know was that for the past 6 months, Musk had been secretly preparing for this moment with an intensity that even his closest associates hadn't witnessed before. Thank you, Justice Barrett, Musk replied, his voice surprisingly steady and formal. I have the utmost respect for my legal team. However, this case involves the intersection of constitutional law, technological innovation, and the future of human communication areas where I believe I can offer this court unique insights that even the most skilled attorney would struggle to articulate without direct experience in creating these systems. Several justices straightened in their seats, slightly taken aback by the measured response. This was not the impulsive tweet first Elon Musk that many had expected. Furthermore, Musk continued, I believe the issues before this court today transcend conventional legal analysis. They require an understanding of how content moderation algorithms actually function, the practical limitations of artificial intelligence in distinguishing protected from unprotected speech, and the global implications of American digital regulation. Roberts and Barrett exchanged another glance, this one less certain than before. As Musk began arranging his notes, the atmosphere in the courtroom subtly shifted. What had begun as an attempt to put an overconfident billionaire in his place was evolving into something unexpected. Mr. Musk, Chief Justice Roberts began the questioning. Your company's core argument seems to be that the FCC lacks statutory authority to implement these specific content moderation requirements. Yet the Communications Act explicitly grants the Commission broad authority to regulate interstate communications. Why should this court create a special carve-out for your platform? The question was designed to force Musk into a defensive position. Immediately, it was a tactic Roberts had employed countless times to identify unprepared advocates. Musk nodded thoughtfully before responding. Chief Justice Roberts, I believe there's a more fundamental question at stake. The Communications Act was drafted in 1934, decades before the Internet existed. While Congress has updated it periodically, the specific provisions the FCC relies upon were never intended to address algorithmic content distribution or user-generated speech at scale. Barrett jumped in her tone skeptical. That's a convenient interpretation, Mr. Musk. But this court has repeatedly held that broadly written statutes can accommodate technological developments not specifically envisioned by Congress in Massachusetts versus EPA, for instance. We found that the Clean Air Act's definition of air pollutant was capacious enough to include greenhouse gases, though Congress couldn't have specifically contemplated that application when drafting the statute. The reference to a complex precedent was clearly intended to test Musk's legal knowledge. Many in the courtroom leaned forward, expecting to see the tech CEO stumble. Instead, Musk didn't hesitate. Justice Barrett, I appreciate that reference, and it actually illustrates a crucial distinction in Massachusetts versus EPA. The court found that greenhouse gases fit squarely within the statute's existing definition of air pollutant. The application was new, but the core regulatory concept remained consistent with congressional intent. Musk turned slightly to address the full bench by contrast. The FCC's current attempt to mandate specific content moderation algorithms represents not just a new application, but a fundamental transformation of the AY's role from technical infrastructure regulator to speech arbiter. This is not merely applying old text to new technology, it's rewriting the AY's core function without congressional authorization. Justice Sonia Stonemeyer, typically skeptical of corporate arguments, leaned forward. Mr. Musk, your platform reaches hundreds of millions of Americans when misinformation spreads on your service. It can affect elections, public health, and national security. Given these stakes, why shouldn't the government have regulatory authority similar to what it exercises over broadcast media? It was a challenging question that had tripped up many experienced attorneys. Musk took a moment before responding. Justice Sotomayor, that comparison overlooks three critical distinctions. He began, first, broadcast spectrum is a limited public resource, which justified greater regulation. Digital speech platforms have no such physical constraints. Second, users actively choose to join and engage with digital platforms, unlike broadcast signals that enter homes unsolicited. And third, the content on my platform is predominantly created by users, not the platform itself, making us closer to a telephone network than a television station. Musk wasn't just holding his own, he was engaging the justices on complex legal distinctions with unexpected precision. Justice Neil Gorsuch, known for his skepticism of administrative power, asked, even accepting your statutory arguments, Mr. Musk, why shouldn't we defer to the FCC's technical expertise in this area? Under Chevron deference principles, this question ventured into one of the most complex areas of administrative law. The doctrine determining when courts should defer to agency interpretations of ambiguous statutes. Musk's response was immediate and direct justice. Gorsuch, I believe this case presents precisely the type of major question that this court has consistently held falls outside Chevron's domain in West Virginia versus EPA. This court clarified that on questions of vast economic and political significance, we should not assume Congress has delegated such authority without clear expression. He continued without reference to notes the FCC's regulations would fundamentally alter how nearly 2 billion people worldwide communicate. They would require my company to restructure its core technology and effectively deputize a federal agency to indirectly regulate protected speech. If that doesn't constitute a major question requiring clear congressional authorization, I struggle to imagine what would the justices begin to exchange. Glances, this was not the performance they had expected. Barrett in particular seemed increasingly engaged, her initial skepticism giving way to genuine intellectual curiosity. Mr. Musk, Barrett said, her tone now noticeably less dismissive. Your briefs cite Professor Lawrence Liesig's concept of code as law, the idea that software architecture itself regulates behavior as powerfully as legal codes. Could you elaborate on how that theoretical framework applies to the specific regulations at issue? It was a sophisticated question that ventured beyond black-letter law into legal theory, seemingly designed to test the limits of Musk's preparation. What happened next stunned the courtroom. Musk stepped slightly away from the podium, his demeanor shifting from defensive to authoritative justice. Barrett, I'm glad you raised Professor Liesig's framework because it gets to the heart of why traditional regulatory approaches fail in digital contexts. Without referring to notes, Musk launched into a sophisticated analysis that integrated constitutional principles, technological specifics, and regulatory theory. When the FCC mandates specific content moderation algorithms, they're not simply regulating business practices, they're effectively coding law into the architecture of the internet itself. The distinction is crucial because algorithmic regulation operates invisibly, continuously, and without the procedural safeguards that accompany traditional law enforcement. He illustrated his point with a technical explanation that somehow remained accessible. Consider Section 4B of the regulation, which requires platforms to reduce the visibility of potentially misleading content. This seemingly straightforward requirement forces us to create preemptive filtering systems that by definition must restrict speech before any determination of its actual legal status. Musk then pivoted to constitutional analysis. This creates a prior restraint problem that this court has consistently treated with the highest level of scrutiny since Neer versus Minnesota. Unlike traditional regulation that punishes after a violation occurs, algorithmic mandate censor prospectively based on probabilistic assessments. The courtroom had fallen completely silent. Even the most skeptical observers could see that Musk wasn't just reciting memorized talking points. He was synthesizing complex legal doctrines with technical expertise in a way that even seasoned Supreme Court advocates rarely achieved. Chief Justice Roberts leaned forward, his initial condescension replaced by genuine engagement. Mr. Musk, that's a persuasive theoretical framework, but let's turn to practical application. How would you suggest regulating genuine harms like coordinated disinformation campaigns by foreign governments without the type of algorithmic requirements you're challenging? It was the kind of question that typically prompted advocates to retreat to vague principles or concede the need for some regulation. Roberts clearly expected Musk to struggle with the concrete policy implications. Instead, Musk offered something unexpected, a detailed regulatory alternative that seemed to have been meticulously crafted to address both government concerns and constitutional constraints. Chief Justice Warren believed there are three constitutionally sound approaches that would better address those legitimate concerns. Musk replied he proceeded to outline a sophisticated regulatory framework involving transparent disclosure requirements, user empowerment tools, and narrowly targeted enforcement against specific illegal content categories. The technical precision was striking enough, but what truly captured the court's attention was how Musk grounded each suggestion in existing Supreme Court precedents, in statutory authorities citing cases, in statutory provisions with the facility of a seasoned legal scholar. Justice Barrett, whose initial skepticism had been most pronounced, asked a follow-up question that signaled a remarkable shift in her assessment. Your framework is intriguing, Mr. Musk. It seems to draw on Justice Kennedy's concurrence in Packingham versus North Carolina regarding the internet as the modern public square, while also acknowledging the government's interest in preventing specific categories of harm. Have you considered how your approach would be implemented given the current statutory landscape? It was a question that treated Musk not as an overconfident amateur, but as a serious constitutional thinker. Musk's response demonstrated not just legal knowledge, but strategic depth. Justice Barrett, I believe the existing authorities under Section 5 of the Federal Trade Commission Act already provide a statutory basis for the transparency and disclosure components for content. Specific regulations, narrowly tailored amendments to Section 230 would be more appropriate than FCC rulemaking. He continued with remarkable precision. This approach would respect the separation of powers by keeping Congress, not administrative agencies, as the primary architect of internet governance policy. A principle this court emphasized in FDA versus Brown and Williamson Tobacco. What had begun as an attempt by Robertson Barrett to put an overconfident billionaire in his place had transformed into one of the most sophisticated constitutional dialogues the court had witnessed in recent memory. Musk wasn't just holding his own. He was advancing novel legal frameworks that visibly intrigued the justices. The Solicitor General representing the FCC looked increasingly concerned as he observed the justices' engagement with Musk's arguments. What should have been a straightforward defense of agency authority had become an uphill battle against unexpectedly formidable opposition as Musk concluded his arguments. Chief Justice Roberts, now fully engaged with the substantive issues, asked one final question. Mr. Musk, given your technical expertise, can you address specifically why the FCC's approach to algorithm regulation is not just legally problematic, but technically flawed? It was the perfect opening for Musk to bring together the legal and technical dimensions of his argument. For the next 4 minutes, he provided a masterclass in how content moderation algorithms actually function, the limitations of AI in distinguishing protected from unprotected speech, and why the FCC's mandated approach would inevitably lead to both overblocking of legitimate speech and underblocking of truly harmful content. The technical explanation was delivered with such clarity and expertise that even the justices with limited technological background could grasp the practical problems with the regulation. Musk concluded by bringing the technical concerns back to constitutional principles. In essence, the FCC is mandating a technical solution that cannot possibly achieve its stated goals without substantial collateral damage to protected speech. Precisely the outcome this court's First Amendment jurisprudence has consistently sought to prevent. As Musk returned to his seat, the courtroom remained silent, observers processing what they had just witnessed. The anticipated humiliation of an overconfident billionaire had instead become a stunning display of legal and technical mastery that had visibly impressed the court. Barrett and Roberts exchanged one final glance, this one conveying mutual recognition that they had seriously underestimated the man before them. Within hours of the oral arguments concluding, legal blogs and news sites were flooded with headlines like, "Musk shocks Supreme Court with unexpected legal brilliance, and tech billionaire outmaneuvers nation's highest court." Video clips of the most compelling exchanges spread rapidly across idea social media, with legal experts expressing astonishment at Musk's performance. "I've observed Supreme Court arguments for over 3 decades," commented Harvard law professor Lawrence Tribe on a cable news panel. "And I can say without hesitation that Musk's presentation ranks among the most impressive I've witnessed. From a non-attorney, the integration of technical knowledge, constitutional theory, and case law was remarkable." Legal Twitter erupted with analysis from stunned court observers. The moment when Musk cited Justice Kennedy's Packingham concurrence and connected it to League's code as law framework was extraordinary, wrote a prominent appellate attorney. He wasn't just reciting memorized talking points. He was synthesizing complex legal theories in real-time. Court insiders reported that during the justices' private conference following the arguments, the discussion had been unusually animated, though the court's deliberations remained confidential. Sources close to several justices indicated that Musk's arguments had significantly influenced the conversation, with multiple justices expressing surprise at the depth of his legal analysis. 3 weeks later, the impact of Musk's performance became even clearer when the court requested supplemental briefing on several of the alternative regulatory frameworks. He had proposed a rare move that signaled the justices were seriously engaging with his suggestions. Rather than simply deciding the case on existing arguments, legal scholars began publishing analyses of the Musk approach to tech regulation, examining how his proposed framework might reshape the relationship between government agencies and digital platforms. Law school professors added the oral argument recording to their constitutional law syllabi as a case study in effective advocacy for Barrett and Roberts. The experience prompted subtle but meaningful recalibrations during oral arguments in East's subsequent technology-related cases. Both justices demonstrated noticeably more humility when questioning advocates about technical matters. Barrett reportedly told students during a law school visit that the experience had been a valuable reminder that legal expertise comes in many forms, and assumptions about who possesses it can be misleading. Roberts, addressing the American Law Institute several months later, made what many interpreted as an oblique reference to the Musk argument. The bench and bar must increasingly recognize that as technology transforms society, the most valuable legal insights may come from those who understand that technology from the inside, not just those trained in traditional legal analysis. For Musk himself, the Supreme Court appearance marked a significant evolution in his public image. While still controversial for his business decisions and social media presence, he had definitively established himself as more than just a technical innovator or wealthy provocator. Constitutional scholars and legal commentators who had previously dismissed him began engaging seriously with his ideas about technology regulation and digital rights. 6 months after the oral argument, when the court finally issued its ruling. In the case, the 7-2 decision largely adopted Musk's position, with Justice Barrett, writing for the majority, her opinion cited his technical explanations repeatedly and adopted much of his framework for distinguishing between permissible transparency regulations and unconstitutional algorithm mandates. Most significantly, Barrett's opinion concluded with a paragraph that many viewed as a direct acknowledgement of Musk's contribution as technological innovation continues to transform how Americans exercise their First Amendment rights. Courts must be willing to reconsider traditional regulatory frameworks and remain open to insights from those who create and understand these new channels of communication. The complex intersection of code and law demands both legal humility and technical precision. The case would eventually be included in constitutional law textbooks, not just for its substantive holdings, but as a turning point in how courts approach the regulation of digital speech platforms. What had begun as an attempt to humiliate a presumptuous billionaire had instead launched a new chapter in American legal history, one that recognized the need for interdisciplinary approaches to constitutional questions in the digital age. Legal commentators would later identify the case as the beginning of Musk jurisprudence, an approach to technology regulation that emphasized transparency and user choice over government-mandated algorithms, and that required regulators to work with, rather than against, the technological realities of digital platforms. For the legal establishment that had initially dismissed him as an amateur, the lesson was clear and humbling. In an era where technology and law increasingly intersect, traditional legal credentials might be necessary but are not sufficient. Sometimes the most profound legal insights come from those who understand not just what the law says, but how the systems it seeks to regulate actually work. What began as an attempt by 2 Supreme Court justices to put an overconfident tech CEO in his place had instead revealed a legal mind of unexpected depth and sophistication, and in the process potentially reshaped the constitutional framework for digital speech regulation for generations to come. If you found this analysis of Elon Musk's surprising Supreme Court performance insightful, don't forget to like and subscribe for more coverage of where technology meets law and politics. Share your thoughts in the comments below. Do you think tech innovators should have more direct input in how their industries are regulated? Your support helps us continue bringing you in-depth analysis of today's most important legal battles.